Let's move on to the final two topics under the heading of consideration. Part payment of debt and promissory estoppel. Now, as you will see in a moment, the two are in fact connected. Let's start with part payment of debt. What's meant by that? Well, part payment of debt is where someone has a debt and they only pay part of that debt. Now, sometimes when this happens, the creditor agrees not to sue for the outstanding amount. Now, is such an agreement enforceable? And the rule is that it is not. So the general rule is that part payment of a debt does not represent good consideration for a promise not to sue for the balance. And of course, given what we've already learned about consideration, this makes perfect sense. If you only pay part of a debt, then you have not satisfied your contractual obligation under the initial contract under which that debt arose, and you have provided nothing new for the promise not to get sued. So the rule makes a lot of sense, and in fact this rule came out of a case called Pinnell's case, which was between a person called Pinnell and another person called Cole. And Pinnell had promised he would not sue Cole after Cole had given him part of the debt that Cole owed to Pinnell. And in spite of that promise, Pinnell then went and sued anyway, and the courts agreed with Pinnell for the reasons that we just discussed. However, the courts also carved out an exception in obiter, of course. And the exception is that where there is any variation in terms of the contractual terms, there the rule may not apply. And the courts used an example. The court said if Cole had not given part payment, but instead had given Pinnell a horse, I think the courts used the example of a horse, well, then it's not for the courts to judge whether the horse is indeed part payment or full payment. In other words, what the value of the horse is to Pinnell. If Pinnell agrees to take the horse and promises not to sue for the debt, well, that's Pinnell's choice. So the rule is very strict in that it only applies to part payment of debt. That means money. So if there's an outstanding amount of money and you give a smaller amount of money, then you may, under all circumstances, still be sued for the remaining amount of money. What if you gave the smaller amount of money, the part payment, and something else? What if you gave the part payment plus a peppercorn that we learned from Chaplin Nestle was good consideration? Well, under the exception in Pinnell's case, that would be okay. You could no longer be sued because you have given the part payment plus something else. Now, whether that something else is big enough, good enough, valuable enough to make up the rest, well, that's really up to the parties concerned when they come to the agreement, and the courts will not inquire into that. Despite being a very old case, Pinnell's case has been affirmed again and again. Let's have a look at some of the cases as examples of how Pinnell's case was applied. Folks and Beer is a very famous case. What happened in Folks and Beer was that Mrs. Beer got a court judgment against Mr. Folks, and Mr. Folks owed Mrs. Beer under that judgment. I think the amount was around £2,000. Now, after the judgment, Folks and Beer came to an agreement that in fact Folks could repay in installments and he would not have to pay interest. Now, once he had repaid the entire amount, Beer sued Folks for the interest. Was she able to do that in spite of having previously promised that she wasn't going to do that? Well, under the rule in Pinnell's case, part payment of a debt is not good consideration for the promise not to get sued for the rest. And since Mrs. Beer was entitled to the interest, there was no contract for the promise not to sue Folks for the outstanding amount because Folks had provided no good consideration. In Reselect Move, very similar scenario, only that it involved the tax authorities. So the tax authorities had promised not to claim an outstanding amount of tax for the part payment of tax, and they sued anyway. And again, the same principle applies. The part payment of a debt does not lead to good consideration for the promise not to get sued. Mahncke and Island Life Insurance is a case from Jamaica where the principle was applied in the same way. This was a case about paying off a mortgage. The Mahncke were paying off a mortgage, and the Island Life Insurance were the party who had given them that mortgage. Now, they were in default, they were not paying, and the Island Life Insurance tried to sell their house, but they were not successful in doing so. Eventually, the parties, that means the Mahncke and the insurance company, agreed that the Mahncke would pay a smaller amount, and in return, the insurance company would not sue them for the outstanding amount. Again, applying Pinnell's case, the court held that the insurance company was still entitled to the outstanding amount. However, in Hirashand and Punamchand and Temple, we have a slightly different situation. What happened in this case was that the Temples were a father and a son, and the son got into debt with Hirashand because the son had borrowed money. Now the father eventually bailed out the son, but the way he did it was as follows. The father made an agreement with Hirashand that the father would pay a smaller amount than the level of the debt, and that would absolve the son of all liability under the initial debt. Now in that case, the part payment of the debt was good consideration for the promise not to sue the son. And the simple reason was because the father and the son are different people, and so these were different contracts. First of all, the son had a contract with Hirashand, and then there was a separate contract between the father and Hirashand. And the separate contract was, of course, supported by good consideration, the father's money. And that second contract basically spelled out that Hirashand would not sue the son. So since we had a situation of two separate contracts, the rule in Pinnell's case did not apply. Strictly speaking, it's not a part payment of debt. Strictly speaking, what it is that the father entered into a contract with the creditor to basically absolve the son. Separate contract, and hence Pinnell's case does not apply. Now, sometimes you may come across the term principle of accord and satisfaction, and the rule in Pinnell's case is an application of this principle. Basically what it means is that the accord means that there's a separate agreement, and the satisfaction means that there's separate consideration. And so in a nutshell, what that means is that if you have a separate agreement, namely the agreement not to get sued, then you have to provide separate consideration. You have to provide consideration which is not part of the existing obligation under the existing contract, hence separate agreement and separate consideration. Now, we move on to our last topic for this consideration lecture, which is promissory estoppel. Now, one of the themes that has run throughout this lecture has been that whatever rule we looked at, you always need consideration. Whether it's past consideration, and we looked at those rules, or whether there is an existing duty, we saw that that can be consideration, but only if you do something over and above what you've already promised to do. So that's really been the theme. So, and what we just saw, even part payment of debt, obviously you're not adding anything new. There's no separate consideration, hence no consideration, no contract. So that's really the theme. Now, the only exception to this idea that you always need consideration no matter what, the only exception is the doctrine of promissory estoppel. Now, it's an exception to Pinnell's case, whereby in Pinnell's case, if you did not pay your debt in full, you may be sued for the outstanding amount. And where promissory estoppel applies, sometimes, in rare circumstances, it may be possible that you owe money under a contract, but you may not have to pay that sum of money. Now, where did this rule come from? Well, originally it came from a case called Hughes and Metropolitan Railway. That case then was sort of forgotten for a long while until it was picked up again by a more recent case. But let's have a look first at what was held in Hughes and Metropolitan Railway. If parties who have entered into definite and distinct terms involving certain legal results, certain penalties or legal forfeiture afterwards by their own act or with their own consent enter upon a course of negotiation which has the effect of leading one of the parties to suppose that the strict rights arising under the contract will not be enforced, or will be kept in suspense or held in abeyance, the person who otherwise might have enforced those rights will not be allowed to enforce them where it would be inequitable, having regard to the dealings which have thus taken place between the parties. What does that mean? Well, to contextualize that, it might make sense to look at the facts in Hughes and Metropolitan Railway. The agreement in this case was for the lease of some land. And the interesting part was that the landlord could compel the tenant to do repairs, not the other way around. But anyway, that was part of the agreement. And in this case, the landlord did compel the tenant to carry out some repairs. But while this was going on, there was a certain period of time in which this had to happen. While this was going on, the tenant, the Metropolitan Railway, negotiated with the landlord to buy the property altogether. Of course, once it bought the property, if it bought the property, all these issues of what the tenant owes the landlord and so on would no longer apply. Now, these negotiations ultimately fell through, and then the landlord basically told the tenant that they were not owning up to their part of the contract because they had not finished the work in the prescribed time. However, the Metropolitan Railway, the tenant, argued that, in fact, while these negotiations were going on, the time limit for these repairs to be carried out was basically on pause because we have to see what happens. And only once the negotiations fell through does the clock start running again. And the court, because of promissory estoppel, agreed with the tenant. So the tenant had an extra amount of time, which was equal to the time spent negotiating, which in fact was many, many weeks, in order to complete the work. So that is promissory estoppel. What it really means is that you can be stopped from enforcing a contract because otherwise it would be unfair to do so. Now there's a number of requirements that go with that, and I think the next case we're going to look at makes this a lot clearer. But it was useful to look at Hughes and Metropolitan Railway, which is really the case where the doctrine of promissory estoppel first arose. And indeed, the case that fully recognized the promissory estoppel doctrine was the case of Central London Properties and High Trees House. Now, before we get to the facts of this case, it's interesting to note that it was Lord Denning who remembered, or might have been pointed towards, the Hughes case from 70 years before Central London Properties, and the fact that that case had established this doctrine. But in the 70 years between these two cases, not much had happened because Hughes had not found much attention. So we really turn to Central London Properties when we look at the doctrine of promissory estoppel as the case that firmly established it. What happened in Central London Property was that this company, Central London Property, had let out some blocks of flat to High Trees House, and High Trees House were going to in turn find tenants to use those flats. Now, their contract between these two parties was concluded just before World War II, and then of course when World War II broke out, many people left London where all this was taking place, and the apartments actually stayed empty for a long period of time. And while they were empty, Central London Property and High Trees House talked about the situation, and Central London Property agreed to accept a smaller amount of rent, and the rent was in fact in form of a lease per annum, while the war was going on. Now, that promise to take a smaller amount was not supported by any separate consideration because, of course, Central London Property and High Trees House already had their contract, and High Trees House had already promised to pay a certain amount in terms of the lease. So how is it then that that promise for High Trees House to pay a smaller amount of rent was enforceable? Now, the court said that where a party promises not to enforce rights and the other party relies on that promise, the promise cannot be revoked even in the absence of consideration. And there's a number of issues we look at especially where we try and distinguish Pinnell's case from the promissory estoppel doctrine. First of all, promissory estoppel in Central London property was a mere suspension of rights. Now, usually it is a mere suspension. Sometimes you will come across a situation where the rights have been permanently suspended, but initially certainly it was a mere suspension rather than giving them up altogether. Also, the promise must have been clear and intended to be binding. The promise must have been relied on, and it must be inequitable to revoke the promise. So these are the criteria for applying the doctrine of promissory estoppel. So if we go back to the Central London property case, let's assume High Trees House was in a lot of trouble because they were under a contract. They had an obligation to pay the lease. They assumed they would have tenants. They didn't have tenants because of the war. So if Central London property had not promised to take a smaller amount, then perhaps High Trees House would have declared bankruptcy or taken some different court of action. But with the promise in mind, they didn't do that. They continued. So they relied on the promise. And in terms of the promise being clear and intended, well, we just look at the actions of the parties. And would it be inequitable to revoke the promise? Yes, because had the promise not been made and not relied on, High Trees House could have taken a different course of action. So all the criteria are fulfilled, and therefore High Trees House did not have to pay the full amount of rent for the period while the war was going on. However, they did have to pay the full amount of rent once the war was over. There's one final case you see there, DC Builders and Rees. That's the situation of inequitableness. How does that work? It's a good example of this. What happened in DC Builders and Rees is that DC Builders had done some work for Miss Rees. Now, Miss Rees hadn't paid DC Builders, and in fact DC Builders were in a lot of trouble financially. Now, Miss Rees knew that or found out about that and offered to pay a smaller amount, and the smaller amount was then going to be in full payment of the entire amount owed. And because DC Builders were in such dire straits, they accepted. They went ahead. Now, under the rule in Pinnell's case, the part payment cannot satisfy the entire debt. And here, in fact, the rule in Pinnell's case was applied because it would have been inequitable to allow Miss Rees to pay the smaller amount and for DC Builders to end up with much less than what the contract was for. So it's sort of the reverse of what we have in Central London property and High Trees House. And of course, as we know, he who comes to equity must come with clean hands. And so we recall this is a rule of equity. This is not a common law rule. And all the equitable rules and maxims apply accordingly. So the application is fairly limited. However, it is an important rule, and it is the only true exception to the rule that you must always provide consideration. So if you get asked, is it necessary to provide consideration in all circumstances? You can say, yes it is, except for this one rule, this one doctrine, that is the promissory estoppel. Let us summarize then the salient points about consideration. First of all, there needs to be a bargain. Something needs to flow in both directions. So for instance, we had Thomas and Thomas, the widow who paid £1 for a big plot of land in terms of the annual lease. Something flowed in each direction. There was a bargain. Secondly, a detriment suffices as valid consideration for promises made. We had the case of Bainbridge and Firmston, where Bainbridge suffered the detriment of not having his boilers for a short period of time. That's a detriment. So you'll remember we talked about there being both a detriment and a benefit on both sides. That's the usual situation. However, the courts will not inquire into what the benefit might be because people have a different conception of what a benefit might be to them. But the detriment is the important part. So if we can find the detriment, then that is sufficient to prove that there was consideration. The consideration must be measurable in economic or monetary terms, Chappell and Nestle. However, those monetary terms can be minute, a chocolate wrapper, a peppercorn, but it must be measurable in those terms. Consideration need not be adequate. Thomas and Thomas again. Past consideration is not good. If you did something in the past, you can't use that for a contract now to get paid for something now. Re Mercado. However, there are the exceptions, and Pao on Lao Yulong lists a 3-stage test. And as we saw, it's not a real exception, because even then, the past consideration is not really past, because right from the outset, parties were clear on the fact that the service or the work or whatever the contract was for was going to be paid for. Performing an existing contractual, legal, public duty does not amount to new consideration. So those are of course 3 separate categories, but under all of those, that's not consideration unless you add something new, unless it's a bit more of what the existing contractual or the existing legal or the existing public duty was. And as we saw with the legal duty, just the promise to keep a child happy, maybe more, maybe above and beyond the mere legal duty to look after the child. So it could be, just like with the peppercorn, it could be something minute, but it has to be something more. Part payment of a debt is not good consideration. So we know this, of course, Pinel's case. Any part payment cannot pay for the promise that you will not get sued, because you need accord and satisfaction. A separate agreement must be supported by separate consideration. And lastly, the only true exception to the rule that we always need consideration is the rule on promissory estoppel. Thank you very much for your attention.